Hi. In this lesson, we're going to discuss the Arizona Real Estate Commissioner's rules. So let's first talk about some very general provisions that the rules have. Remember, the rules, as we discussed in a previous lesson, are not law, but they have the force and effect of law on you and me as real estate licensees. So first of all, document filing. The Commissioner's rules say that applications for a license are timely if they're postmarked by the deadline, by the appropriate deadline. This is to obtain a license and also to renew a license. Actually, in almost all instances today, people don't send things in by mail, they just handle it over the internet. But the law still deals with the possibility that someone might send something in by the mail. Now, if your license is not renewed on a timely basis, and we'll see this again in a minute, there's a penalty fee, a late fee, if you don't renew your license on a timely basis. Now let's talk about licensure and some general requirements. First of all, one of the things that you will have to fill out in order to obtain your license is what's called a licensee disclosure questionnaire. This is a long questionnaire which asks a number of rather personal questions. Have you ever been arrested or convicted? Have you had judgments levied against you, the subject matter of which involves real estate? Have you had professional licenses revoked, and so on? That's the licensee disclosure questionnaire that you have to provide to the department as part of a number of things to obtain your license. You're also going to have to provide them with a fingerprint clearance card. You're going to have to give them your Social Security number. You're also going to have to provide them with proof of legal presence here in the United States. Now, in our orientation video, we discussed this stuff in much greater detail. Now, please realize you can only have, you only have one license, and that license can either be a broker or a salesperson's license. To become a broker, as you know, you have to be in the business at least 3 years. So you cannot have both a broker's license and a salesperson's license. Nor can you use your broker's license for more than one purpose. For example, some brokers ask me, Jim, can I be the designated broker of this company here and do property management, and be an associate broker for this other company over here and do sales? The answer is no. One license. You can only be a broker or a salesperson. You can't be both. Nor can you use your license for two different purposes. The name that appears on your license has to be your legal name. Even though you may use a common nickname, the name on your license has to be your legal name. And all advertising is actually supposed to be in your legal name. However, oftentimes, for example, my name is James. My legal name is James, but I go by Jim. And it would not be confusing to the public if I advertised my name as Jim Hogan as opposed to James Hogan. You'll have to file your business and home addresses with the Department of Real Estate. So not just your business address, but your home address. However, your home address is not public information. The Commissioner's rules require notification to the ADRE if within 10 days a licensee is convicted of a felony or a misdemeanor. Also, what if someone, a licensee, has an adverse judgment levied against them, the subject matter of which involves real estate? That would have to be disclosed to the department within 10 days. What if you had another professional license? Say you were a doctor or a dentist or an attorney, and you had a restriction placed on that license, or that license was suspended or revoked. You would have to notify the real estate department of that restriction, suspension, or revocation. Also, you have to notify the Department of Real Estate when you have a change of your home address within 10 days. Now, if your company changes their business address, the company is supposed to notify the department of that change immediately. But if you move, you're supposed to notify the department of that change of address, home address, within 10 days. Also realize that when you renew your license at the end of the 2-year renewal period, you will be asked these questions through that licensee disclosure questionnaire, which is filled out at the end or at the renewal of a license. And those questions relative to license suspensions or convictions or judgments or change of address are asked. So remember, if any of those things happen to you, notify the department within that 10-day period. Let's take a couple of minutes and talk about license renewal. If you don't renew your license is said to have expired. Not suspended, not revoked, just expired. Please realize the term suspended or revoked implies some disciplinary action. So you simply fail to renew, your license is expired. And you can renew actually on an early basis. You can renew up to 90 days prior to your license expiration, and there's certainly no penalty for doing that. As you know, however, there is a penalty for renewing late. And if you do renew past the expiration date, and you might recall you have a 1-year grace period, we discussed that in another lesson, you have 1 year after your license expires within which to renew it. But if you do renew late, you must disclose any activity, any real estate activity that you had where you helped buyers, sellers, landlords, or tenants during the period of time that your license had expired. And this might cause you to have to supply some extra information to the Department of Real Estate. It might subject you to disciplinary action if you did conduct business when you were not licensed. It would also might mean that you'd have to go back to the people who paid you commissions and offer them their money back. As we mentioned earlier, there is a fee, a late fee for late renewal. You don't have to know what the number is, but realize there is a penalty, a financial penalty for renewing late. One of the questions that sometimes comes up is, if I want to leave a brokerage firm, do I have to have the broker sever me? And the answer is no. The answer is the department now allows what's called an administrative severance. In other words, you as a salesperson or an associate broker, you could actually sever yourself from the company without your broker's permission. Years ago, the broker had to sign off saying that you were severed, and you could not do that on your own. Well, you can do that now, either with paperwork or electronically through the department's website. We talked in another lesson about branch offices. A separate branch office license is required for a firm, and the manager of that branch office can be either a salesperson or an associate broker. For designated broker acts, in other words, if the branch manager wants to perform designated broker functions like reviewing and initialing contracts, hiring and firing people, that person must be an associate broker. It cannot be a salesperson. For the branch office, we talked a little bit about this in another lesson. A license is required. The exception to that, however, is for an on-site subdivision office. For example, let's say a home builder has their corporate headquarters in a nice office building, but they have 3 subdivisions around town where they have model homes. If all they're doing is conducting on-site subdivision work at those subdivisions, they do not have to have separate branch office licenses at those subdivisions. One of the major sections in the Commissioner's rules is on advertising. So first and foremost, there can be no blind ads. In any of your advertising, you always have to identify the fact that this is a real estate company who is doing the advertising, so it doesn't appear like a for sale by owner or for rent by owner. So the name of the real estate company must be in the ad. Now this extends even to internet advertising, even to Facebook posts and other posts on social media. When you as a licensee are buying or selling your own property, or leasing or renting your own property, you must disclose that you are a licensee. So the wording owner agent should be in all of your advertising. Now, even a for sale sign on your property. Let's say you work for ABC Realty and you put an ABC Realty sign out there on the front of your house. Well, you should have one of these sign writers on that ABC Realty sign that says owner agent. That tells any prospective purchaser that not only is the property for sale, but it is a real estate licensee who owns the property and is acting as the agent in that transaction. The Commissioner's rules require that ads contain accurate information. There can't be any false or misleading or inaccurate information in the ad. So, for example, always check your advertising to make sure if you're stating what the zoning is, if you're stating what the size of the parcel is, if you're stating the square footage of the property, that all of that information is accurate and not misleading. The employing broker's name, the company's name, must be prominent on all advertising. I mentioned earlier that includes internet advertising, social media advertising. And where websites are concerned, what the real estate commissioner wants to see is that it's on every web page, not just on the home page, but on every web page and at the top. Why? Well, because different people use different browsers. So they want the consumer to understand immediately that they're dealing with a real estate company. And since people don't just always come through the home page, but they access different pages of advertising through many, many different means, that every page should contain the name of the brokerage company. And let's be smart about this. You know, one of the things I hate about searching things or looking for things online, if I get on somebody's website and I want to contact them, I want to buy something, or I want to ask a few questions, half the time there's never a phone number. All they want me to do is type in my name and my email address and send them an email about the question. And of course what they're trying to do is capture my email address. Well, there's nothing wrong with trying to capture someone's email address, but you want people to contact you, so give them many different ways to contact you. Include your phone number, and again, not just on the home page, but include it on every page of your advertising so it's easy for them to pick up the phone or to send you a text. You want to make sure people can get in touch with you. Realize it's the broker who must supervise all advertising. So if there are false claims in the ad, not only can you be held liable, but the broker can be held liable as well. How many square feet in an acre? You know it, you got it, 43,560. And inside a football field, basically from end zone to end zone, not including the end zones, it's just about an acre. Now don't quote me exactly on this, but I think if you do the math, you'll find that it's just about an acre. There's no such thing as a commercial acre. There's no such thing at law as a subdivision acre. If you're going to use the term acre, you have to be referencing it to 43,560. Now you can say plus or minus if it's pretty close to 43,560, but if it was 30,000 square feet, you'd never say, oh, it's an acre minus. You wouldn't use that. Always make sure your advertising is as accurate as possible. One of the things you may not realize is, but our commissioner's rules require that we must have the owner's written permission in order to place a sign on a property. I remember years ago there was a brokerage firm here in town that understood the value of a sign. And he pretty much dealt in land, and he would go out into the boonies and he would put signs out, big signs on properties, so people driving by would see his name all over town if they were looking for land. Well, in many instances the broker unfortunately did not have the owner's permission. He could have been subject to disciplinary action for that and lost his license. One of the questions that comes up often is, can I give my client a premium? Can I say, buy a house from me and I'll give you a big screen TV? Can I say, list your property with me and when we sell it, I'll pay some of your moving expenses? The answer is yes, you can. Even though these people are not licensed, and it would be illegal to pay an unlicensed person a referral fee, we talked about that in another lesson, when you're dealing directly with a client, there's no problem in giving a client a bonus or a premium. So saying, buy a house from me and I'll give you a TV, that is no different than saying, buy a house from me and I'll reduce my commission. Nor when you agree to pay some of a seller's moving expenses, are you doing anything else but reducing your commission. So when you're dealing with the client, even though that client is unlicensed, it is okay to give them a premium. Now, premiums are okay, but you cannot use the word prize or award. This is not a contest. You may be encouraging a buyer to buy through you or a seller to list through you. That's a premium, but it's not, and it can't be referred to as a prize or award. You also would have to disclose the terms and conditions. In other words, if you say buy a house from me and I'll give you a big screen TV, you'd have to disclose what the specific terms and conditions are in order to get that TV. You also are not allowed to conduct lotteries or contests or drawings. So for example, even though it's okay to say buy a house from me and I'll give you a TV, you couldn't say buy a house from me and I'll put your name in a hat to draw a TV drawing at the end of the year. That would be a contest or a lottery, and that can't be done. The exception to that is for subdividers and timeshare developers where they want to have some sort of a lottery or promotion where they get permission from the Department of Real Estate. But in the resale of homes, for example, you cannot use any kind of lottery, contest, or drawing. The next item on our hit parade here is compensation, and there's one commissioner's rule that addresses compensation, and basically what it says is that you must disclose all of the brokerage companies who are sharing in compensation, all of the brokerage companies that are representing a client in the transaction. What that really means is that if you have a buyer's broker and a seller's broker, that both of those brokerage firms, their names and the commission sharing have to be listed in the closing statement. But if you're paying a referral fee out of your commission to a third party, does that have to be disclosed in the closing statement? The answer is no, it does not. Another section of the commissioner's rules deals with documents. Conveyance of documents. One of the things that you should realize is that people expect to get a copy of something when they sign it. So if I asked you to sign on the dotted line for something, wouldn't you want a copy of what you signed right away? Well, that's really all this commissioner's rule is saying, is that you should give copies to all parties as soon as practical, as soon as practicable. And in today's world, many of the contracts are prepared electronically. You might be out in the boonies somewhere, a buyer says, I want to make an offer. You take out your iPad, you fill out the contract on your iPad, the buyer takes their fingernail, signs it, and boom, you've got an offer there. Well, at that particular point in time, you can instantly send that buyer a copy of that document. Same thing, the seller signs and accepts a contract, make sure they get a copy. Commissioner's rules say you've got to do it as soon as practical. How about submission of offers? Well, all offers must be presented. I think you realize that all offers must be presented. So if you have an offer in hand, then you get a call from another agent and says, well, an offer's coming in on the property, you don't just run to your seller and say, hey, I've got this offer, accept it. You have a fiduciary duty to your seller to do what? To present all offers. So you've got to submit all offers promptly to your client up through the date of closing. What do you mean? Do you mean to tell me that if the seller has accepted an offer and you're in escrow, proceeding to closing, and a week or two later, another offer comes in from another agent on the same property, you have to submit that? The answer is yes, you do, unless the seller has instructed you in writing not to submit any other offers. Now, most sellers would want to know they had another offer on the property. And if that offer was better than what they had, then what you could do is inform the seller that they could accept it, but only as a backup offer, and only if it would go into effect only if the first transaction that is proceeding towards closing fell through. So it's pretty rare that a seller would actually tell you, don't show me any other offers. But if they tell you that, you want to get that instruction from them in writing. There's a major section of the Commissioner's Rules which deals with professional conduct. And the first part of it deals with duties to clients. So if we represent a seller through a listing if we represent a buyer through a buyer brokerage agreement, if we represent an owner through a property management agreement, if we represent a lessor or a lessee in trying to list or lease a property, we have fiduciary duties to the clients. We can remember these duties by the acronym CARLOAD, which we discussed in another lesson. That stands for confidentiality, accounting, reasonable skill and care, loyalty, obedience, and disclosure. We also have certain duties to customers, and our commissioner's rules say that we have to be fair with all other parties to the transaction. So that includes fairness, honesty, acting in good faith, and disclosure of material facts. So mandatory disclosures include the seller's inability to perform in the transaction. So you find out that the seller is bankrupt. Whoops, that seller is not going to be able to perform. You have to disclose that to the buyer immediately. How about the buyer's inability to perform? What happens if you find the buyer can't qualify for the loan? Immediately you must inform the seller or the seller's agent. What about material defects? Well, the commissioner's rules say that you must disclose any material fact, including material defects, which would adversely affect the consideration to be paid in the transaction. So you've got leaky roofs, bad plumbing, you've got termites, you've got structural problems. All of those are material defects. They must be disclosed. How about the possible existence of some lien or encumbrance on the property? So you get the preliminary title report and you see that there's a judgment against the seller or an income tax lien against the seller. That has to be disclosed to the seller. Actually, the seller might not have been aware of those situations, might have forgotten about them, but in addition, of course, the buyer has to be informed. What about if the property is in the vicinity of a military or municipal airport? That has to be disclosed. As well as, and I don't have it on the screen here, what about fissures, F-I-S-S-U-R-E-S? Certain areas of the state are subject to the ground cracking and opening up, usually because of the fact that we have overdraft, more groundwater taken out than nature is replenishing. So add to the list here fissures. But let's go back to the military airport. Here's an airport boundary map of the Tucson International Airport. Here's one of Davis-Monthan. And if you look up really close, I'm going to enlarge this for you. If you're familiar with Tucson, the vicinity of Davis-Monthan extends well beyond where the base is. It actually extends north of the Rillito, well north into Craycroft Road. So you wouldn't normally think that a house up in the lower foothills along Craycroft would be in the vicinity of Davis-Monthan, but it is. These maps for all of the airports around the state can be found on the Department of Real Estate's website, as well as maps indicating the areas where there are fissures around the state. One of the things that the Commissioner's rules require us to do is to perform acts expeditiously. That's a mouthful. All right. What does that mean? Well, basically what we're talking about here is get a move on. There are a lot of time frames in a purchase contract that must be met, and if those time frames are not met, then either the buyer or the seller could overturn the transaction. There's a closing date in the purchase contract. Make sure that you get everything done that needs to be done in a timely fashion to meet that closing date. That's what we mean by performing acts expeditiously. One of the things we can't do is let a controversy with another licensee interfere with the client's transaction. Let's say you and another licensee are having a dispute over a commission, and you say, hey, I'm not going to let this close until we get this commission dispute resolved. Well, baloney. You have to let the transaction move forward and close, and then take care of your dispute with the licensee after the closing. What about conflicts of interest that you might run into? And there's a myriad of situations where a conflict of interest might arise. For example, what about you acting as a principal? If a licensee is the buyer, seller, landlord, or tenant, that has to be disclosed. And whenever you might think about buying a property that you might have listed, there's a conflict of interest there. Whenever you have a situation where you might buy a property that you've shown a buyer and the buyer's indicated that they have interest in it, yet you go ahead and make an offer, that's a substantial conflict of interest. How about the buyer or seller is an immediate family member of you or of your broker? In that circumstance, you must disclose that to the participants in the transaction. So you're making an offer on behalf of your brother. Now, your brother may have a different last name than you. All right, in that circumstance, it might not be obvious, but you have to disclose to the other party in the transaction that this offeree in the transaction is your brother. How about if the buyer or seller is the designated or employing broker or owns the brokerage firm? In those circumstances, you would have to disclose that to the other party in the transaction. What about if the salesperson, the broker, or a family member has a financial interest in the transaction? This is a good example here. What if your sister works for the mortgage company that you're referring your buyer to? That's a potential conflict of interest. And of course, what about the possibility that the company that you're referring them to is an affiliated company, the mortgage company or the title company or the escrow company or the insurance company is owned or partially owned by the company? That disclosure would have to be made. And when you are representing a family member, you're going to have to disclose all family members that you represent. One of the things you will need is written consent for dual compensation. If you receive compensation from more than one party in a transaction, you must get all parties' written consent to that dual compensation. Also, as we discussed in another lesson, you would have to get written consent, what's called informed consent, when and if you act as a dual agent in a transaction. You also have to have written consent if you receive additional compensation in the transaction. The Commissioner's rules specify, and you have this in your course material in greater detail, specifies that if you're receiving any kind of additional compensation that results from or is related to a real estate transaction you were involved with, that you have to get the parties' written acknowledgement and consent for that additional compensation. Lack of expertise. I love this photo. I'm a snorkeler and a scuba diver. If you're out of your depth, if you're swimming in a pond you don't belong in, you must disclose your lack of expertise. I may have told this story in another session, but it's applicable here. I got a call one day from a young man who had just finished his licensing course, and he said, Jim, he said, I need the 5-minute course on commercial real estate. He had just had his license about a month. And I said, well, don't you know the Commissioner's rules say that if you don't have expertise, you should bring somebody else into the transaction who does? He says, I don't need it. I got a big deal coming along, and I want the 5-minute course on commercial real estate. Well, this guy was out of his depth, and I know he was going to get into some trouble. So if you do not have expertise, you must disclose it to the client, and then if the client still wants you to proceed, get their written acknowledgement that they allow you to proceed. We also are required under Commissioner's rules to obtain and communicate any information that would pertain to the client's interest. So it's so important that we stay in contact, and even though you think that something might be trivial or not too important to the client, continue to keep the client informed, and I would argue on a daily basis. You know, the purchase and sale of a particular property is always top of the mind to buyers and sellers. They go to cocktail parties. They're always talking about their transaction. They're trying to sell their house. They're thinking moment to moment about, gee, what can I do to make my property more saleable? So they're thinking about selling, buying, leasing, and renting property 24/7. Keep that in mind. Stay in contact with your clients. How about the situation when someone says, you know, can I have a set of keys? I just want to go look at the property. Please realize, as a licensed real estate agent, you will have access to numerous properties through key safes and other means. Make sure that you only give keys or allow people to have the keys who are authorized to have them. there's all sorts of potential liability to allowing other people into properties who are not authorized. One of the things that you cannot do is to allow occupancy by a third party without the owner's permission. You know, it's been known that people have gone into vacant homes, the real estate agent lets them in through the use of the key safe, and they throw big parties. Here we have the Animal House. Remember that movie? You don't want that to be happening. So you may not allow occupancy by a third party without the owner's permission. You never, ever, ever want to allow possession of the property prior to closing without the expressed written instructions of the owner. You also might want to recommend counseling to your owner regarding the legal risks of allowing a buyer to move in before closing. In another lesson, I believe I talked about a situation where a seller allowed a buyer to move in prior to closing. They deep fried a turkey, burned the place down. So you would always want to make sure your seller client, if they wanted the buyer to move in before closing because they wanted the rent and the house was vacant, that you got their express permission and you recommended that they speak to an attorney or other counselor relating to the risks involved. The Commissioner's rules require certain things relating to property negotiations. You must negotiate through the principal's exclusive agent. In other words, let's say there's an exclusive listing on the property and you have a buyer. You can't go directly to the seller. You must negotiate through the listing agent. Unless the principal waived that requirement and you can't contact the agent for over 24 hours. Now, the only time that this really might happen is if you have a one-person brokerage firm who has the listing and they're out of town and out of contact with the seller. You try to communicate with them to present the offer, but they're not available. In that circumstance, after 24 hours, you'd be able to go directly to the seller, inform the seller of the situation, and if the seller agreed, you could present the offer. However, you better get it in writing before you present the offer. In other words, the seller's authorization in writing, explaining the situation and allowing you to present that offer. Another question is, who's responsible? Who's the responsible party for anything that goes wrong? Well, the answer, of course, is the employing broker. The designated broker is the responsible party. And brokers have the responsibility of supervising their licensees. And a broker has to prepare a written policy manual. And this policy manual must be available to all of the licensees in the company. So whenever the question comes up as to who's responsible, who is it? It's always the employing broker. If you're interested in accessing the statutes, rules, and policy statements on the Department of Real Estate's website, in the bottom left, there's a link there to laws, rules, and policy statements. Click on that link. Or if you're more interested in having a book, check out the Department of Real Estate's law book. This has all of the pertinent statutes we've been talking about and Commissioner's rules, plus a lot more. So that's it for our discussion on the Arizona Commissioner's rules.